Welcome, everyone. My name is Lincoln Davies, and I have the honor and privilege of co-directing the Stegner Center along with my colleague Brig Daniels here at the University of Utah S.J. Quinney of Law. We're delighted to welcome you this afternoon to our final Greenbag of the semester, the Trump Presidency and the Environment. This is an all-virtual event, and we have many speakers here from within the Stegner Center at the University of Utah, as well as friends of the Stegner Center who've taken their time to join us and to talk about environmental, energy, and resource policy under the new administration. I want to thank you for joining us throughout the year at our various events, including our Greenbag series, our Young Scholar Lecture, and our annual symposium. As I mentioned, this is the final event for this academic year, and we're currently planning additional events for next academic year. So please keep an eye on the Stegner Center calendar and join the Stegner Center listserv. There's sign-up information on our website, so you'll get emails on upcoming events. Today, we're going to be discussing, as I mentioned, energy, environment, and resource policy under the Trump administration. We have many speakers here to join with us to talk about this. What we're going to do is each speaker has about 9 to 10 minutes to present in their area. And then at the end, we'll have time for questions. So please use the question and answer function. If you have any questions you'd like to ask our panelists toward the end, we'll have an open discussion at that time. And in that function, you can upvote questions so that they move to the top of the queue. So we're using a democratic process to source the most interesting the questions in which people are most interested. So we're going to begin with Professor Amy Wildermuth, who is a visiting professor of law at the University of Minnesota Law School. Many of you may be familiar with Professor Wildermuth. She taught for many years here at the University of Utah and was a member of the Stegner Center faculty and long has been a friend of our college and the university and the Stegner Center. So please join with me in welcoming Professor Amy Wildermuth.
Thank you, Lincoln, for inviting me today. It is terrific to see so many old friends and to be part of this discussion. I've been asked to kick us off with some big ideas about administrative law and the Trump administration, and particularly the civil service. With so much going on, let me begin by saying we have the danger of conflating two different projects happening in administrative law now. One that began at the Supreme Court around 2010, but has become increasingly noticeable in the past few years, and the separate project that the Trump administration has engaged in. While there's much to say about what the Supreme Court is up to and what that might mean for environment and the natural resources right around us, I'd be happy to take questions about that later. The Trump administration actions are largely out of step, in my mind, with that Supreme Court project, which is truly saying something. So to get a sense of the Trump project, I'll remind us of some numbers that many of you may now be too familiar with. Under the current Trump administration, the EPA has been reduced in 3 key ways. First, in February, as many of you know, the EPA terminated 388 probationary employees, much like they did in many other agencies. These individuals were primarily in their first year of service and did not have full civil service protections. But notably, that does not mean their dismissals were lawful, as courts are beginning to sort out. Of course, the second category, there was an additional 171 staff members, particularly those involved in diversity, equity, and inclusion and environmental justice programs that were placed on paid administrative leave. And then, of course, there's 300 career employees that we know of so far who have resigned, citing concerns over the agency's direction and the administration's policies, right? Some of these resigned, some of them retired, right? But it is a loss of at least 300 employees. And then there's the looming, as of yet to be fully articulated, planned workforce reduction. The administration has said it wants to reduce the EPA's workforce by 65%. That's equating to approximately 11,000 positions. Now, while some layoffs have occurred, the full extent of this reduction is uncertain because the administration has been slowed by the ongoing legal challenges and administrative reviews. Now, we can repeat similar numbers across other environmental and natural resource agencies. The BLM is down 800 employees. The National Park Service has lost 1,000. The impact of these layoffs has been particularly pronounced in western states like Utah, where the BLM manages over 40% of the land. In Utah alone, 55 BLM employees were either fired, resigned, or had job offers rescinded, and we don't have nearly enough time to meaningfully discuss what this might mean for public safety and management of the very popular national parks in Utah. Now, there are lawful ways that the federal workforce can be reduced, and there are lawful ways to rethink who is protected by civil service laws. These are important questions for any president to ask and important for us to consider as a country. The problem, of course, is that the Trump administration has shown little interest so far in following the lawful paths to go about these reductions. In fact, civil service law provides for reductions in force, or RIFs, and my colleague here at Minnesota, Nick Bednar, has a great post on Lawfare about how those laws work, as well as a good explainer on reclassifying workers in the civil service. One of the notable things one can take away, and some of you will remember, is that it was President Clinton who reduced the federal workforce substantially by nearly 400,000 individuals using these mechanisms. What the Trump administration is doing, however, seems to be something else. So let me close by reminding everyone about what the first Trump administration did with BLM. In 2019, the administration decided to move the headquarters of BLM to Grand Junction, Colorado. Out of 328 positions slated for relocation, only 41 employees made the move. When Biden proposed to return the headquarters to DC in 2021, while keeping Grand Junction as a Western hub, it still had a very difficult time filling its vacancies. Most reports indicate that BLM was nowhere close to full employment at its headquarters when Trump took office. I suspect, just as in the case of BLM, the real effort here is not necessarily to engage in the kind of planned reductions that the civil service laws imagined. It instead seems to be a more shock and awe approach to reduce the institutional memory of agencies and perhaps even to discourage people from working at agencies in the future. Which raises one more theme that I have not yet mentioned, and we can pick back up on this in the Q&A. This is the question of loyalty. There is also, as you are all well aware, an element to what the Trump administration is doing that is about a unitary executive theory that would return to a political spoils kind of system rather than the civil service as we know it. You see it in the language of the president and in the many efforts to require federal employees to do what the president says, including those in independent agencies. While that too is certainly at play, I think the far more impactful piece of this effort now is the reduction of the workforce to be as small as it possibly can be. Which leaves us with a final question. Who or what will be the substitute? Is the vision one that private entities will step in? Or is it the states? Is it some combination? Or perhaps this is just a permanent and forever loss of knowledge and capacity in these spaces. So thank you again for having me, and I look forward to the rest of the discussion.
All right. Thank you so much, Professor Wildermuth. I'm sure in the Q&A, there are going to be a lot of questions about sort of overall directions in the federal government. And just encourage everyone again in the audience, if you have questions, to go ahead and put those in the Q&A, and we'll be returning to those at the end of the presentations. We're next pleased to hear from Professor Bob Kiter, who is a distinguished university professor here at the University of Utah, the founding director of the Wallace Stegner Center for Land Resources and the Environment, which he used his tremendous leadership for over 30 years. to lead our center, and he is the Wallace Stegner Professor here at the University of Utah S.J. Quinney College of Law. Bob.
Thanks, Lincoln, and thanks to everyone for your interest in joining us today. As Lincoln mentioned, it's my pleasure to spend a few minutes talking about the public lands and the President Trump's and his administration's agenda in this regard. To start with, the first question in my mind is, what do we know at this point? What are the sources that we can turn to get a sense of where things are headed with respect to the public lands? It seems to me there are several. Who are the appointees who will be making decisions? What executive orders to date has President Trump issued? What about Secretary of the Interior orders that are relevant to this? And then lurking in the background, as I suspect everyone's aware, is Project 2025 and the recommendations that came forth from there. Let me start briefly with the appointees that might give us a sense of what decisions might be forthcoming. First of all, as Secretary of the Interior, Doug Burgum, the former governor of North Dakota, is the confirmed secretary. His background coming from North Dakota is obviously heavily tied to oil and gas development that is occurring within that state that he's promoted. But interestingly enough, according to news reports about Secretary Burgum, he's got a strong affinity for Teddy Roosevelt and his attachments to North Dakota, where he formed much of his conservation agenda. In fact, the governor was a major proponent of establishing a Teddy Roosevelt Museum in the western part of the state next to the park that bears Roosevelt's name. In addition, he's reported to have a strong relationship with the state's Native American tribes. So that might give us some hint of someone with sort of mixed interests stepping into that position. Associate Deputy Secretary in Interior is Karen Budd from Wyoming. Budd Phelan is her last name. She brands herself a cowboy lawyer. Was involved in President Trump's initial administration, where, among other things, she played a major role in reforming or revising endangered species regulations. She's litigated regularly against the public land agencies in her private capacity. The Forest Service Chief is Tom Schultz, who hails from Idaho and from the forest group in that state, which is focused principally on timber. His background includes, however, directing the Idaho state lands and a similar type position in the state of Montana. Heading U.S. Fish and Wildlife Service is Brian Nesvik, also from Wyoming, who spent the latter part of his career overseeing the Wyoming Game and Fish Department, where he promoted, among other things, wildlife migration corridors. The BLM position is currently vacant as the administration seeks another appointee. In terms of President Trump's executive orders, probably the most important things in general regarding those is, first of all, many of them have been directed toward reversing his predecessor, President Biden's executive orders, particularly those dealing with climate change and focusing energy development with respect to climate change and on promoting alternative energy, reversing those. That includes, among other things, reversing the Outer Continental Shelf lands withdrawals, reversing the coal moratorium, and various clean energy executive orders from President Biden. So President Trump's focus, I think everyone is aware, is on energy, promoting energy independence and dominance, a term from his first term. He's declared a national energy emergency. This will impact ultimately, primarily, but not exclusively, the BLM lands, where we'll see oil and gas, coal, nuclear, hydro, biofuels, all being promoted through expedited leasing under the Mineral Leasing Act and permitting under that same act for exploration. There is a specific order regarding resource development in Alaska, and that traces back to the Project 2025 report. In addition, executive orders focus on developing further energy infrastructure, transmission lines, pipelines, and similar that run across federal public lands. And all of that is to, again, expedite the development of these, if you will, traditional energy resources. It's fair to say that there may be some headwinds with respect to this agenda. First of all, there's a degree of uncertainty that hangs over a number of things, one of which is the fact that climate change impacts continue to exist and to be felt. Another is the deep political divide that continues to exist not only in Congress, but more generally and within the states and market realities that could impact an aggressive, more traditional energy agenda. Certainly, there will be litigation challenges to leasing and permitting decisions. There's a good deal of case law that provides grist for NEPA, endangered species, and like challenges. Likely to see those challenges emanating not just from the traditional non-governmental organizations, conservation groups, but I think we can expect to hear from state attorneys general in blue states when confronted with development that they disagree with. This may not stop the agenda, but it will certainly slow the process. In terms of market forces, open question whether aggressive coal agenda will take hold. Permitting of new mines will take some time, not to mention potentially additional coal-fired power plants if anyone is inclined to build them under the existing market realities. And at least based on some reports, finding miners to work in mines could be a challenge here. Critical minerals, which was also on the Biden agenda, is on the Trump agenda, driven by, according to the executive orders, national security concerns. And here again, I think we'll see efforts to expedite exploration and development under the general mining law. There have been a number of withdrawals implemented administratively by previous secretaries. We can expect those to likely be rescinded, opening more land to prospecting, etc. Underlying this, again, is the question of how the laws will apply, the handles they may provide for those inclined to challenge expedited critical mineral exploration. A few other matters that I think will come to the fore, national monuments that now, for the moment, seem to be linked to the energy agenda, given the Secretary of the Interior's order for review within the department of the energy potential on existing national monuments. And of course, there's the history with President Trump of having reduced in size significantly the two Utah national monuments, Bears Ears and Grand Staircase Escalante, which, if the administration proceeds in that direction, will certainly prompt litigation, probably predicated upon a case that is still pending from his first administration in federal court in Washington, D.C. the Bureau of Land Management, in order to try to expedite things, will probably seek to repeal some of the Biden-era rules that were adopted, in particular the conservation rule and the methane rule and other rules that are related to climate change and energy development. As I believe Professor Wildermuth noted, the issue of moving the headquarters to the west, BLM headquarters to the west, is likely on the agenda. It certainly was part of Project 2025's recommendations. President Trump has issued orders to accelerate timber harvesting levels on national forest and BLM lands. That includes seeking to revise Section 7 consultations under the Endangered Species Act and using categorical exclusions in NEPA to ramp up sales, as well as aggressively employing the so-called Endangered Species Committee, or also known as the God Squad, to approve sales that might otherwise be precluded. This, I think, raises questions also regarding how market forces will play here, and the reality that many, many mills over the last 20, 25 years have closed across the West. The real problem in the forest seems to be wildfires, particularly in the WUI interface, wildland-urban interface. And the question I think the administration will face is the degree to which they might be interested in using prescribed burning as opposed to thinning, and the issues involving commercial utilization of small diameter wood that is thinned. I think we can likely expect another effort to revise Endangered Species Act regulations, drawing upon President Trump's prior administration. And something similar may well occur with respect to NEPA. My colleague John Ruppel will be addressing that, I believe, later on, so I won't go into that. But at any rate, these laws are likely to slow any accelerated development agenda. While we're on the Endangered Species Act, some issues, specific issues out there include potential efforts to delist the grizzly bear in the Northern Rockies, how to proceed with the protection for the sage grouse to avoid its listing, and we may well see some activity in establishment of federal wildlife corridors. As far as the national parks and recreation go on the public lands, staffing, as Professor Wildermuth mentioned, is likely to be an issue in terms of management there. Given the nature of President Trump's constituency, likely I suspect that we could see pressure for additional motorized recreation, off-road vehicles, as well as hunting on the public lands. In Congress, Senator Mike Lee from Utah has a bill to sell public lands to address the housing shortage. Whether that will pass remains to be seen. I should note that the Federal Land Transfer Facilitation Act provides an alternative already to address this. And then finally, more broadly, staffing cuts across all of the DOI and agencies in the Forest Service means we've seen a loss of expertise. And the underlying question is, where do we get the staff? Where do the agencies get the staff to implement an aggressive development agenda? Happy to take questions afterwards.
All right. Thanks so much, Professor Kiter. You really covered a lot of ground there. So next, we're pleased to hear from Professor Lingxi Chenyang. Professor Chenyang is an associate professor here at the law school and a member of the Stegner faculty. She is an expert on food policy, climate change, and environmental law, and she's going to address Trump policies, policies of the Trump administration on climate change. Professor Chenyang.
Thanks, Lincoln. Thanks for inviting me. It's great to be here. So I've been asked to talk about climate change developments and likely policies under the Trump administration. And the high-level summary is that the Trump administration is attempting to roll back basically everything the Biden administration has done on climate change and more in an effort to promote fossil fuel production and consumption, as Professor Kiter discussed. So I'll talk about two sort of predictable developments under the Trump administration and two novel developments. One predictable development was President Trump's announcement of his intent to withdraw from the Paris Agreement. This is an international treaty that asks countries largely to make voluntary climate pledges and asks wealthy countries to give, mostly on a voluntary basis, funds to developing countries for climate mitigation and adaptation projects. It'll take a year for U.S.'s withdrawal to go into effect, and it effectively removes the U.S. from international leadership on climate action, even though the U.S. Remains the second largest greenhouse gas emitter in the world and the largest historical emitter. Notably, President Trump has not withdrawn from the UNFCCC. This is the underlying treaty framework that the U.S. Senate ratified in 1992. Another predictable development are regulatory rollbacks. So President Trump has issued a barrage of executive orders rolling back President Biden era regulations meant to reduce U.S. climate emissions. A major one is that the Trump administration redirected the EPA to reconsider its 2009 determination that greenhouse gases endanger public health or welfare. This was a very important determination because it triggers the EPA's duty under the Clean Air Act to regulate greenhouse gas emissions. The Trump administration has also disbanded the interagency working group on the social cost of greenhouse gases. This is a tool used to help administrators evaluate whether a regulation designed to curb climate change is justified. So those are the procedural rollbacks. There are a few substantive rollbacks that were predicted as well. President Trump directed that auto emission standards under President Biden be reviewed and scrapped. Those regulations apply for cars and trucks starting in the model year 2027. The EPA has also said that it will reconsider the Biden administration's regulations on new and existing coal plants. And President Trump himself, via executive order, has granted coal plants a 2-year exemption from complying with emission standards for hazardous air pollutants. My colleagues have talked about permitting on federal land, so I won't talk about those. There have also been novel developments under the second Trump administration on funding freezes. Just to review, the centerpiece of President Biden's climate policy was not actually conventional regulation. It was actually 2 spending bills. This was the bipartisan infrastructure law passed in 2021 and the Inflation Reduction Act passed in 2022. And together, they're estimated to spend trillions of dollars in tax credits and other types of federal funding to ramp up clean energy. So on the first day of the Trump administration, President Trump issued an executive order directing all federal agencies to pause the disbursement of funds under the IRA. And there have been several challenges to these funding freezes. The single largest IRA program is the Greenhouse Gas Reduction Fund. So the EPA Administrator Zeldin has tried to terminate some of these grants that were already awarded under the IRA, under the justification that the grants constitute a green slush fund and are vulnerable to appalling waste and fraud. So 4 states, California, Illinois, Minnesota, and Maine, and several nonprofits who were contracted to receive the funds sued for breach of contract and violation of due process. And the DC District Court issued a temporary restraining order on some of the funding freezes under the justification that there was no evidence of fraud and waste. Currently, the House Energy and Commerce Committee is investigating the disbursement of funds. So that's something to watch out for. The second development on funding freezes is in late March, the Trump administration requested the DOE, the Department of Energy, to come up with this hit list of federally funded clean energy projects to cut. So these are funded under both bills. And interestingly, they've awarded around $15 billion for hydrogen and carbon capture. These technologies are compatible with fossil fuel power plants. So we'll see if red states challenge this policy. The last thing I'll talk about is a recent attack on state climate policies, and this is sort of a new development. So President Trump issued an executive order last week calling on the Attorney General to, quote, expeditiously take all appropriate action to stop enforcement of state climate laws that the administration considers to be essentially illegal. And it named 3 laws, the New York and Vermont's climate superfund laws. These were passed last year, and they impose a charge on large historic carbon polluters to help fund the costs of climate adaptation. The executive order also named California's cap and trade bill. This was enacted in 2012, and it essentially allows power plants and other climate polluters to trade carbon credits, and it's been quite effective in reducing statewide energy emissions. So the broad consensus among legal scholars is that this executive order doesn't have any force of law. States have traditionally been allowed to exercise their police powers to regulate air quality and carbon emissions. Notably, the administration's position on state laws also seems to be contrary to the longstanding position of the Republican Party and conservatives on states' rights. So those are the 4 categories of developments. And in conclusion, again, the Trump administration is attempting to roll back almost everything that the Biden administration has done on climate change and more. I think the legality of many of these actions is questionable, and we'll see efforts by states and nonprofits benefiting from these policies to challenge them. I think it's particularly worth tracking the legal challenges to climate funding freezes. Those will have effects, long after the Trump administration. Also worth tracking are these new federal attacks on state climate laws. It'll be interesting to see what will happen in any future confrontations between the federal government and states.
All right, thank you so much, Professor Chen Yang. We're next going to hear from Professor John Ruppel, who is a research professor here at the University of Utah Law School, as well as the head of the Wallace Stegner Center's Law and Policy Program. Professor Ruppel served in the Biden administration and is going to address permitting and NEPA under the Trump administration.
Well, thank you, Lincoln, and thank you to everybody that's joining us today. It really is a pleasure to talk to you all. A lot's happened since we first started talking about having this green bag, and I'm going to talk a bit about NEPA, but before I do that, I want to pull back and talk a bit about environmental regulation more broadly and make sure we don't miss the forest for the trees. I'll try and situate NEPA in that broader context. I want to make 4 points. The first, I think, is it's important to remember why we have environmental regulations and permitting requirements in the first place. They're there to make sure that the air we breathe and the water we drink doesn't make us sick. They're there to make sure that we don't drive species into extinction. They're also there to respond to lessons we learned from the Watergate era, to ensure that decisions are made in an open and transparent way, and that we give voice to impacted communities. I think when I think of kind of the case for environmental regulation, I think of Love Canal. And if you're not familiar with that, it's the story of a decision to try and build a diversion canal. It was abandoned because it didn't make geologic or economic sense. It was followed by a misplaced decision to use the abandoned canal to store hazardous waste, and by a later disastrous decision to build a school on top of that abandoned canal. It's precisely the kind of deadly decision that regulations like NEPA can prevent by taking a look before we leap approach. Now, this is not to say that regulations are perfect. There's ample opportunity to improve regulatory efficiency and permitting without compromising environmental protection, government transparency, or meaningful public engagement. But that requires an understanding of what isn't working. And I'm not sure that moving fast and breaking things is really the best approach. So the second point I want to make is that elections have consequences, and every new administration comes in and they make changes. It's common for new presidents to issue executive orders, pausing rulemaking while the new administration evaluates pending rules. It's also common for a new administration to come in and initiate rulemaking to repeal or amend regulations. But that's not really what I think the Trump administration has been doing so far. So I went back and looked through the Federal Register, and through April 11th, so the first 82 days of the administration, the Biden administration had published 501 proposed rules. The Trump administration over that same period had published just 233, so less than half the number of proposed rules. It's not to say they've been inactive. What we've seen is a lot more executive action. Over that same time period, the Trump administration issued 124 executive orders. And to put that in context, the Biden administration over that same period issued 48. They issued 162 over the whole entire 4 years of their administration. And I think these numbers are important because we may be seeing a shift towards more directed regulation, where the president orders agencies to regulate or to deregulate in very specific ways that minimize the amount of discretion agencies have moving forward. And I think that the potential to limit discretion may have implications for notice and comment rulemaking. And I just want to point out one recent executive order in this regard. On Friday, the president issued an order on maintaining acceptable water pressure in shower heads. And it states, and I'm quoting here, "Notice and comment is unnecessary because I am ordering the repeal." Now, I hope there's some students online from administrative procedures. If you're an admin law student, I think you'll find this a pretty shocking statement. But now turning to NEPA, I think it's really an example of the kind of overzealous deregulation we're seeing with the Trump administration. NEPA, or the National Environmental Policy Act, is the Magna Carta of environmental laws. It was enacted in 1970. It establishes national environmental goals. It promotes public engagement and transparency in decision-making, and it directs federal agencies to consider the environmental impacts of their actions before they act. It doesn't prevent actions that harm the environment. It simply requires the agency to look before they leap. NEPA also creates the CEQ, or the Council on Environmental Quality, which was charged with advising and assisting the president in implementing NEPA's goals. In 1977, President Carter issued an executive order directing CEQ to promulgate regulations and require all federal agencies to comply with those regulations. The goal was to create a common floor and avoid conflicting practices across those various agencies in the federal family. And the order was issued in large part because prior to that, CEQ had been issuing guidance, and there was confusion about the binding nature of that guidance. So it led to different implementation programs. On his first day in office, President Trump issued an executive order repealing CEQ's rulemaking authority and ordering CEQ to repeal all of its NEPA regulations. Now, it's important to understand that the statutory mandate of NEPA remains in place. Agencies are still required to consider impacts before making a decision. But now we miss out on that common floor across the federal family. We have 441 federal agencies listed in the Federal Register. And each of those, or the departments in which they're housed, is now going to have to come up with their own procedures to comply with NEPA's substantive and procedural requirements. That's going to take a tremendous amount of work. And frankly, I think it's a tremendous waste of time. There's a huge risk of inconsistent requirements across those agencies. I think that would be bad for permittees because, if you're a permittee and you're trying to move forward with an action that requires approval from multiple agencies, that inconsistency is going to cause confusion. It's likely to invite litigation if the law is implemented in different ways. And in the end, that's going to make it harder to build projects, energy infrastructure in particular, regardless of whether you're interested in building more oil and gas wells or more solar farms and electric transmission. The problem is going to be the same. The difficulty moving forward is going to be real. And agencies that are already spread thin and absorbing huge staff cuts, they're being asked to do an awful lot more. So I want to close with the fourth point. I'll be brief here. I think there is a better path forward. First, it's to make sure there are people available to do the work. you can't get a permit approved or an environmental analysis completed if there are no federal employees there to do the work. It's as simple as that. I think there's an opportunity to promote coordination and collaboration to make sure processes run concurrently rather than sequentially. And I'm not sure that that's going to happen under the Trump administration's approach. And I think there's also an opportunity to incentivize best practices. So I'm going to leave it there and happy to answer questions at the end.
All right, thanks so much, Professor Ruppel. We're next pleased to hear from Sharon Buccino, who is a research fellow here in the Law and Policy program at the Stegner Center, and previously was the head of the Office of Surface Mining, Reclamation, and Enforcement for the Biden administration. Sharon.
Thank you, Lincoln. I'm going to be batting cleanup with a little bit more on energy, which we've heard really is a theme for pretty much of the Trump agenda. So chaos, confusion, there's definitely a lot of it. But what there isn't any uncertainty about is where this president stands on fossil fuels. And he's all for them. It's drill, baby, drill. And as we heard from the Interior Secretary last Wednesday, it's also mine, baby, mine. I'm going to just highlight a few of the most significant actions. I think it's very important, though, in processing them, that we distinguish words from actual change on the ground. So as John just mentioned, in terms of the numbers of executive orders, this president is clearly leading by executive order. Now, as has always been the case with executive orders, they articulate direction. Some of that direction can have immediate effect. A lot of it, however, takes further action by agencies within the executive branch to turn the order's words into results. So I'm going to aim to distinguish between some of these words and then where there have already been some results. Professor Kiter already mentioned several of the first executive orders. 3 of the 10 executive orders that the president issued on the day of his inauguration focused on energy. One was about unleashing Alaska's extraordinary resource potential that did include opening the door to drilling in the Arctic National Wildlife Refuge. A second one, Unleashing American Energy, established energy exploration and production, but also the elimination of what was called the electric vehicle mandate as national policy. The third, and I would say this is probably the most significant one, declared a national energy emergency. And so why do I say that this is the most significant one? It's because declaring a national emergency can provide a basis for waiving requirements like environmental review and public participation that would otherwise apply. So we saw this with the border wall in the first administration, and now the president is really laying the groundwork for waiving existing laws through executive authority in many other contexts. There are a couple of key legal questions involved here. What are the criteria that apply to determining an emergency? And will the courts defer to the executive interpretation of whether an emergency exists? The goal, I think, is pretty clear, and it's been stated explicitly, and it's dominance. So much for balance, or even the pluralism that rests at the heart of our Constitution. Notably, despite the president's and his party's support for property rights, this national energy emergency executive order opens the door to the use of eminent domain, which provides for the government taking of private property. But let's turn to some of those some of the very recent energy actions, and one that took place just last week, last Tuesday, was the executive order reinvigorating America's beautiful clean coal industry. And in this order, the president directed the Interior Department to identify where coal resources exist, impediments to accessing this coal, and policies to address the impediments. It went on to say that where coal exists on public lands, President Trump declared mining the priority use of these lands. So questions there regarding whether that is consistent with existing laws that mandate a multiple use approach to the management of our public lands. I'd like to just highlight a few now of the agency actions that have taken place, because as I mentioned, much of what's in those executive orders requires further action by federal agencies, and they are starting to act. So we saw earlier this month, the Interior Department announced an offshore oil and gas lease sale in the Gulf of America. And in addition, the Interior Department leased 25,000 acres onshore in 6 states: Montana, Nevada, New Mexico, North Dakota, and Wyoming. It also promised at least 10 more onshore lease sales this year. It was already mentioned that funds for critical infrastructure, including wind and solar energy, have been frozen. And yes, while it's true that the legality of such action has been challenged in court, new grants are being delayed, and some, in fact, have been withdrawn that were already issued. So what are some of the consequences? 1, dominance has replaced balance. 2, it's always an emergency, so existing laws arguably don't have to apply. And 3, and this is where I'll end, we continue to face uncertainty, instability, and inefficiency as each new administration spends time and money reversing much of what the previous one did. So what are the solutions to get to a different place? As John just mentioned, conversation and collaboration, and also finding common ground from the bottom up and the middle out. Thank you.
All right, thank you, Sharon. We now have just over 10 minutes for time for questions from all of our panelists. I'm going to turn to the Q&A function where you can put in questions if you'd like, and you can upvote those if there's some that the crowd is more interested in than others. Let me turn to the first question that was asked, and this will be for our first speaker, Professor Amy Wildermuth. What happened to the APA in the environmental law context?
That's a great question. I think all of us have touched a little bit on this, but I'll be as direct as I can be. As Professor Ruppel pointed out, the administration seems to be, shall we say, at a little bit of a distance from APA principles in some of the pronouncements that they have made, and obviously in the many executive orders that are issued rather than going through the normal APA process. That seems to indicate something about a sense of the APA. Now, I will note, with respect to the showerhead EO, I just have to say, and many of you know this, it appears that the showerhead rule was in fact an interpretative rule, which of course all the good admin law students online will say, we can amend that just by simply noticing it if that is true, right? So instead of it being some, mysterious or great power, it might just be actually what we have under the APA. But the threat is yet, right, still quite real. And that is it true? And this is, I think, what Professor Ruppel was getting at, that in fact, what we're saying now is that the APA may not directly apply to the president. So if the president takes all the action, you just don't have to worry about the APA altogether. Now, if that's true, everyone, that means take your CFR and it's gone, right? And I don't think that argument holds up. It's based on Franklin v. Massachusetts, right? But it is a bigger issue than maybe one might think of from that showerhead EO.
All right, terrific. So Sharon, let's come back to you. There's a question about the role of tariffs and whether they'll undo the economics favoring exploitation of coal development. Thoughts on that front?
Well, I think the biggest impact, I mean, it's going to be across the board, and it's still yet to be seen. But the energy markets are global markets, and so the tariffs are clearly going to affect them.
Just as a follow-up, do you have a sense in which way you think they may affect coal development in the U.S.?
I don't. I think the immediate driver is the different approach that the Interior Department is taking and accelerating already. We saw it was the Spring Creek coal mine in Montana. An expansion of that was authorized. The expansion was inconsistent, I think, at least arguably inconsistent with the environmental analysis that had been done and that the decision did rely on. So there's some vulnerability there, but I think it's what's going to happen with these agency decisions. I would be remiss not to mention, though, that while some federal funds, a lot of them have been frozen, just last week also, after acting on the Beautiful Clean Coal executive order, the Secretary of the Interior did announce the release of $13 million to several states for the work to reclaim abandoned mine lands. So that is a good thing that's moving forward, because that's what helps coal communities do something else with those lands and repurpose them for future economic prosperity.
Good, great. Let's come back to you, Professor Ruppel. There's a question about staffing and NEPA compliance and timing. How much do you think that the NEPA amendments will allow proponents to prepare NEPA documents and litigate and mitigate those issues? Do you see any other issues related to the shift, to the potential shift away from agency staff preparation to proponent prepared documents affecting how NEPA is implemented?
I think it's a great question. I don't know that we're going to see a huge change in impact on the ground. Section 107 talks about proponent completed documents, but that's not a revolutionary concept. It's been very common for proponents to hire third-party NEPA contractors through contractual arrangements with the agency in order to prepare EAs or environmental impact statements. Moving it now to where the proponent can prepare those on their own. I don't know that that changes the game dramatically, because NEPA is very clear. The final decision remains with the federal agency, and the federal agency is responsible for the quality and the content of those NEPA documents. So while it may be faster in some ways to prepare the document, the agency still has to review. They have to buy off on the methodologies. They have to buy off on the conclusion. And if you have fewer people available to review those documents, you're still going to have a backlog. So I don't know that proponent prepared documents are going to lead to necessarily faster decisions, especially if there's nobody there in the federal agencies to review or sign off.
All right, thank you. Let's turn back to Professor Kiter. There's a question, Bob, in the Q&A about what effect the Trump administration policies might have on Utah's effort to acquire federal land.
I'm sorry, Lincoln. I was trying to get on. Could you repeat the question?
Yeah, no worries. So there's a question in the Q&A about what effect the Trump administration policies might have on Utah's effort to acquire title to federal land in the state.
I guess that's a little bit hard to say. I mean, the federal government obviously will take a position in that litigation, and it's a little difficult to see the federal government, just walking away from the land resources that it has had for centuries and not resisting the state's efforts. But on the other hand, this administration that is likely to be receptive to a lot of state arguments. So, I think we wait and see. But again, I think I would be surprised if the federal government did not resist the arguments that are being made. The breadth and scope of what that might mean in terms of the public domain would be enormous. But we've been surprised by the first and now the second Trump administration. So I'm not putting any money on my observation there.
Okay, that's great. So we've got another question. I'm not sure who might want to take this, so I'm just going to ask it to the group, and we'll see if somebody wants to jump at it. Given political disagreements and congressional deadlocks, and then of course the sort of large number of executive orders we've heard have been coming down the pike from the Trump administration, can businesses take action and spend money on the basis of those executive orders, for instance, opening a mine, and move forward, or does this make environmental law in the U.S. much more turbulent? And if it's more turbulent, can parties who take actions based on executive orders today make claims for compensation in the future?
I think that's a really important question, and I think it goes to the importance of, and it will be interesting to see the various alliances that we see emerging to really come together around, I would say, some kind of middle ground. That's ultimately the solution, because the turmoil and the uncertainty and instability is not in anybody's interests. And teaching very vividly, I remember in teaching public land law as the Biden administration was beginning after the 2020 election. Students asked me to say, well, how can this be a good way of governing when each administration just spends all of its efforts reversing the actions of the previous one? And it's not. So we have to get to that place where we are having conversation and we're collaborating to find solutions for local communities, for states like Utah, and for the country.
Can I just make one quick addition? And
Yeah.
Sharon, I agree with everything you said. The one point I'd make is that executive orders don't undo the underlying substantive statutes and laws. So, yes, they make it appealing for a mine developer or whoever to move forward, but that entity still needs to comply with the law. So, executive orders are important, but I don't think they necessarily answer the question in all regards.
Okay, we're almost out of time, so I'm going to take two last questions. These are the two most popular questions in the Q&A. The first one, I think either Professor Wildenmuth or Professor Chen-Yang. The question is about how is Chevron and the reversal of Chevron last year by the Supreme Court affecting federal resource decisions?
Well, as Lincoln knows, I have an article coming out about this, and I actually think that Loper-Bright didn't change too much, which I know might be a controversial statement to make in a very short period of time. But I'll refer everybody to our article, which is going to come out in the NYU Law Review. But basically, I think there's a piece of Loper-Bright that has a delegation of discretion in it that says, look, where there's a delegation of discretion, right, we'll look for reasoned decision making. So I'm not certain that that's what the driver is here anyway. I think a lot of us have answered questions now that basically say Trump administration is kind of going outside of what we usually think of as the normal administrative process. And so to have Chevron or Loper-Bright play a role it might be a welcome change to some of the things that are happening, because it would be a little bit more in the main lane of what we would expect from an administration.
Okay, and then our most popular question is, what are the most important things we can do as citizens to fight to protect our environment and tackle climate change today? I don't know, Professor Chen-Yang, do you want to take a stab at this one?
Yeah, I love that question. I think, as law professors, we assume much of conflict resolution happens in the courts and everyone is a good faith actor following the rule of law, in our democracy. I think many of these assumptions are being challenged. in the current moment. And I think the most powerful way to register, if you have displeasure with the regulatory rollbacks, the funding freezes, the backsliding on climate environmental policy, is to show up to town halls, show up to protests, show your state representatives, your displeasure at the state events.
All right. Thank you so much. We are at time. So thank you to each of our panelists. We really appreciate you presenting and the time and effort you've put into that, sharing your knowledge and expertise with our audience. Thank you to members of our audience for joining us. We remind you to watch the Stegner Center calendar for upcoming events in the coming academic year. And with that, thank you. Good afternoon and be well. Take care.